Right from the start, the judge establishes something critical: structure over chaos. This isn't just a divorce hearing, it's a cleanup operation after failed mediation.
I would like to go ahead and see a final an end to. We went through mediation to try to reach an agreement on several topics, which you had forwarded to the mediation group, and we did not meet a resolution on any of them. And after talking to the director of the mediation services, she recommended it go to the judge because she could not solve the mediation disagreements.
Okay, so what are you asking the court to do?
Make a judgment on several points. The mediator had forwarded to your office her findings.
Okay.
And I'd just like to go over them point by point so we can finally reach a resolution on a lot of these points.
Okay, why don't you tell me what the first point is you'd like to address?
The first point was, let me see, I don't have a printer anymore. I have to look off my screen. It says Jody, Sarah, and Stephen Sarah have reached partial agreements on the following. Jody agrees to deliver the 2013 Toyota Highlander vehicle titled to Stephen Sarah, agrees to sign the title immediately to remove his name from the title and mail back to Jody, which I did sign the title. I received it on the end of at the end of January. I have not received any indication from Jody as to whether or not that has been submitted to the SOS to take me off of the title. This has been going on for a couple of years now.
All right, Miss Sarah, have you got that title to give to Mr. Sarah?
Not to give to him. I have the title in my name.
Okay.
Now, part of the resolution was I was to receive proof that I had been removed from the title, which I have received none.
All right, what proof do you want?
Yeah, exactly.
For well,
My address, Your Honor, my
Miss
address
Sarah,
is on
Miss
all this
Sarah, hold on,
paperwork.
hold on. Miss Sarah, we're
Sorry.
gonna do this one at a time. I asked Mr. Sarah a question. I didn't ask you for input. Mr. Sarah, what do you want from her to prove
I
it?
would like a copy of the title or at least a photograph of the title with my name removed, because as of now, I'm still on the title and as such responsible.
Okay, Miss Sarah, can you do that?
It's been done, Your Honor. I have the title in my hand. Problem is, it has my address all over it, and I don't want him to have that.
You can delete that. You can marker that out, or if you have Photoshop, you can easily eliminate your address. I don't care about the address. I just want to see a clean title with my name removed, which I have not, Your Honor.
Miss Sarah, can you send him a copy of that with his name off of it?
Right there, sure.
Okay, next point, Mr. Sarah.
Jody and Stephen both agree that neither are in a position to make payments or pay in full the student loan debt. Stephen
Stephen has
agrees to
nothing to do with that.
Okay,
Pardon me?
Miss Sarah, Miss
I'm
Sarah,
sorry. Yes,
I'm not gonna keep telling you this.
okay.
Please don't interrupt. When I need a comment from you, I will ask you. Go ahead, Mr. Sarah.
Stephen agrees to try and contact student loan carrier to see if they will take payments from each, Stephen and Jody. I did, and they will not. They expect the loan has actually gone to a collections agency, so it is out of the hands of the student loan debtor, and it's now in a collection agency's hands. I and I assume Jody are in the same boat where this is a $250,000 loan. Neither one of us can either make payments or pay off it in full. We each bear half. So as of now, it just stands where it is. I believe as much as I would like Jody's half of the student payments, I can't make them myself, so I can't. I'm at a quandary on what to do on this. So as far as the mediator goes, this was basically at a standstill, and it's not exactly a negotiation between Sarah and I.
Okay, so what
Uh,
are you asking to do about that?
Honestly, I am in no, I don't have the money. They want for $250,000 loan, they want twice what I pay on a mortgage. I don't have it.
I
So,
understand that. Well, what are you asking me to do about it?
well, they're threatening to um um take part of my Social Security. So if they do, which they have not yet, I collect Social Security. They have not yet taken part of that, but if they do, I would like to reduce the amount I would owe to Jody because it's in part of my payment for the um, student loan. I know this is
Okay.
convoluted and I didn't make sense. I'm sorry.
No, that makes sense, but that hasn't happened yet, right?
No, it has not. It's they just sent me the letter saying they were going to I forgot the legal term, take part of my Social Security payment. And I don't know how much it will be. They did not give me an amount.
Okay, so that, I guess that's a bridge we'll have to cross when and
That's
if that happens.
exactly that is exactly true, sir. Um,
Okay,
the next item was Stephen agrees to owe Jody $2,061 for two vehicle payments in March and April of 2025, insurance payments 325 and 425, and a March payment for the pension, which is my part of the pension is 928. I believe Jody receives 933.
The student loan issue exposes a hard truth. Not every problem has a courtroom solution. Mr. Sarah presents a financial crisis, but the judge immediately redirects to jurisdiction. What can actually be ruled on? This is where many litigants fail. They bring real-life stress, expecting legal relief that doesn't exist.
My question to the court, Your Honor, is for those months of March and April, I was paying $1,000. Jody did receive a pension for one of those months, but in addition, I'm to make auto and insurance payments, and that adds up to a lot of money that I just don't have, and I don't understand. Maybe the court can explain if I am truly responsible for at the same months I owe auto payments and auto insurance, I'm Miss Sarah's receiving half my pension and $1,000 cashier's check. So she's receiving, I believe, more than she is entitled to for those 2 months. What I would like to see is the two vehicle payments and the insurance payments knocked off. I did pay $1,000 and a per month, which she received, and she did get 1 month's pension payment, which would make me responsible for 1 month's pension payment of 933, depending on if, like I said, I get 928, Jody gets 933. I don't understand. I'll pay her the 933 for the month I owe her, but I would like to see the two vehicle payments and insurance payments seem to be more than I'm owing for those 2 months, and I don't understand.
well,
I would
this,
like
this
those.
says in the last sentence of that paragraph, this says these funds will be deducted from the payment for the firearms, so those are gonna be credited. So it's
Correct.
not an amount you have to pay.
Whatever the court decides, I will abide by.
Well, I'm not deciding anything. I'm just going by what the agreement says. It says you owe that much, and it says these funds will be deducted from the payment for the firearms. So that's money that Miss Sarah is not gonna have to pay you for the firearms. That's how that's going to be equalized.
Okay. Okay, agreed. The next paragraph, Stephen agrees spousal support of $1,000 per month has been paying regularly from March through April, November 25, which was the last time we had the mediation, I believe. Stephen agrees to continue paying $1,000 per month until Jody is eligible for Social Security, which at this time is scheduled for July of 2026. So I have kept my agreement, and I have been paying $1,000 per month, which I don't believe is contested at this point and is scheduled to end. Jody turned 62 in June of 2026. So that should be my last payment to Miss Sarah.
I will start getting Social Security in August. I'm sorry to interrupt.
Okay. All right, Mr. Sarah, what's the next thing then? That sounds like that's taken care of.
Okay. Jody and Stephen agree Jody is receiving the pension directly from the company on a regular basis. And I don't believe that has changed. So Jody is receiving her pension payments directly from the company.
Okay. All right.
It's the next one is there's only two more. Stephen and Jody do not agree on the value of the firearms and would like a determination of those items. Stephen claims the value of the firearms listed on the exhibit are not the current value, but what he paid for them many years ago. Stephen also claims the list is not complete. There were many guns not listed, such as a 1911 pistol. I will add AR-15 was not added. A couple of black powder guns were not listed, although my son has custody of those. I don't have a problem with that. And many assorted BB and pellet guns. Jody claims to not have the guns, but is aware the judge has ruled she is to reimburse Stephen. Now, the last time we were at mediation, she did not agree that she owed me money for these, and that for me is the main outstanding exhibit for today, that Jody is in fact responsible for those firearms as set forth in the divorce agreement. As far as them being not of the value I'd like in the divorce agreement, it says she will pay the value of the firearms. That's just a sticking point, whether the value is what that piece of paper, which was for the ATF, was just a registration, and the price I paid for them at time of purchase, and not necessarily the value of those firearms. Although I have not submitted anything to the court otherwise. So Your Honor, I guess I'm asking that Jody agree that she does owe some money for the firearms, whether or not it was the declared value to the ATF or the true value of what they were worth at the time they were stolen.
Okay, well, I'm looking at paragraph 5 of my ruling on the divorce. And that's on page 9 of my ruling from last February. And that says that the court awards to the defendant all the firearms listed in defendant's exhibit I, which was admitted by your attorney, Mr. Sarah, during the trial.
Correct.
Which the plaintiff must have returned to him.
The judge shifts into enforcement mode, and the tone becomes unmistakably firm. The ruling is already clear: return the firearms or pay their value. Miss Sarah's concerns about safety and logistics, while emotionally valid, are irrelevant to the court's role.
So, number one, that means any firearms that the plaintiff has or has within her control through your son or in any other way, they have to be returned to you. If any of those firearms have been disposed of, or in other words, sold, or just gone and can't be returned to you, then the defendant is entitled to receive the value of those firearms according to the values listed in Defendant's Exhibit I. So I've already made a decision on what those values are, and the values are what they were listed as in your exhibit. So we don't have to decide the question of value because it's going to be according to that. And so Ms. Sarah either has to give you those back or she has to pay you those values minus the amounts that you owe her under the mediation agreement for those March and April payments. So those should be deducted from the amount that she has to pay you for any firearms that she can't return. So to me, that answers the question of what needs to happen. And any other firearms that weren't included in your exhibit, I mean, that's water under the bridge. That's too late now. That should have been something that was brought up by your lawyer at trial. So, Ms. Sarah, I don't know how many of those guns you still have or your son has, but you need to either return those guns to him or pay the amounts that are in that exhibit. Do you understand
Can I ask a question?
Sure.
How do I return the guns to him safely, keeping me and my son safe, and get him to admit that we gave them to him? Because he told my son could sell them all and keep the money, or he could return them and he would say he never got them. So
Well,
where am I
about
supposed
any
to
of
go?
that? And I don't, again, as I've told both of you before, my job is to make decisions in this case. It's not about how to give you advice about how to carry out those decisions. So you're an adult, you're fully capable of figuring out a way to return what needs to be returned to him or pay him the money. And so you need to do that.
Can that be done in the court parking lot?
That's not up to me.
Okay. All right.
Again, you're both adults, you're fully capable of figuring out how to arrange for that transaction. But that's not part of my job, is to tell you what to do, what not to do. Because I'm not going to be responsible for what you guys do or don't do.
Okay. Can I ask what the total was again?
I don't have that exhibit in front of me, but you should have that in your materials.
Okay.
So that addresses that issue. And I'm gonna give you 60 days to do that, Miss Sarah.
Okay.
Okay. And Mr. Sarah, you said that's the last issue that you have, correct?
There was one more, Your Honor. The last item was Stephen and Jody agree there's still some of Jody's property left in the marital home. Jody agrees to find someone to go to the home for her with boxes, tape, packing materials to retrieve these items. Jody agrees to send Stephen an email regarding the time frame for the pickup. Jody agrees, Stephen at least 1 week notice. My only issue with that, and I did give a guidelines for moving document to the mediator, which I know Jody should have gotten a copy to. I believe I copied her on it. Basically said if she can't come up with people to move stuff out, I would pack her items or pack items very carefully and work with her movers under the guidelines for moving. Basically, the guidelines for moving were just basically for my safety and hers and Jody's. I don't expect her to be here. She'll designate movers. And I will go ahead and box up the final items that Jody had left here. My question to the court would be, it's been over 3 years. I agree to return items, but it has been over 3 years. that she abandoned this property that I've been taking care of. My question to the court would be, is Jody still entitled to these items? But again, I said I go ahead and return what I can return.
I think if they're her things, yeah, it doesn't matter how much time has gone by. If they're hers, they're hers. So she should get them back.
Thank you.
And the agreement is that there's still some of Jody's personal property left in the marital home, and looks like at mediation you agreed to return those things to her. So, and I think this last paragraph in the mediation agreement is a very reasonable method for having that done. So, does that answer your question, Mr. Sarah?
Yes, it does, sir.
Okay.
The final issue brings everything back to principle. Ownership doesn't expire with time. Mr. Sarah attempts to introduce the idea of abandonment, but the judge rejects it cleanly. If the items belong to her, they must be returned. Simple as that. This reinforces a consistent judicial approach throughout the hearing. Agreements and ownership rights override personal frustration. The 3-year delay doesn't change entitlement. What matters is what was agreed upon and what still exists. The judge validates the mediation framework, signaling that despite its failure to fully resolve the case, its structure remains enforceable. With that, the court moves to formalize everything into an order. No drama, no lingering debate, just closure. The system doesn't need resolution to feel satisfying. It only needs it to be final.